Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer.
I wanted to talk to you today about our theme, because as we mentioned, we tend to get recurring client calls and emails, right? Every week, every month, we get a little bit more of one thing than maybe some others.
Yeah, that's what started this whole thing.
That is what started this whole thing. And lately, it's been non-COVID issues. Thank goodness.
Yes,
right?
that has been fun.
Yes. Most generally, clients are not having to change policies, create policies, pivot, right, every other day for COVID. And they're starting to think about what they were working on.
Yes,
they're brushing the dust off their 2019
I
to-do
do
list.
have that mental picture, right, of our wonderful HR folks sitting at their desk and thinking, what was I doing on March 1st, 2020, and opening a drawer and pulling that out and putting it on their
What were my job
desk?
responsibilities before I was the public health department for my little corner of the world? And
exactly.
I took employees' temperatures every day.
Exactly.
What did I do with my mornings?
Yes.
And one of those things that we have seen quite a bit.
Oh yes, the standard go-to, really, right?
Are you ready?
Like, I know exactly.
Should we
what
say
you're
it
gonna
together?
say. No, you just go ahead.
The handbook.
Yeah, right.
The good old handbook.
I have been getting quite a few requests from clients asking us to look at their handbooks, right? Which is wonderful. That says to me, yes, people are recentering, right? They're recentering, they're going back to what they know.
Yep.
And pulling that out and thinking about and asking us what needs to be updated.
What's changed?
What has changed.
From the before times
to now.
Right, as we say, the before COVID time. So I don't think we should go through an index or a laundry list of everything that should be in a handbook, because I might actually fall asleep sitting here talking to you.
We could check with our producer to see if we have 6 or 7 hours to record today. No, Jeff? No. All right. So, yeah.
Okay.
Let's just pick what we think are the most important then.
Perfect. Let's pick not just the important things, but maybe what's changed, right? And what has changed in the last 2 or 3 years that people should be paying more attention to.
Yes.
And let's do it.
It's good.
Let's just have fun with it. We will give each other 5 jumbled letters, and the handbook topic that we want to talk about will include all of those 5
Oh, my
letters.
goodness. Okay.
But the handbook topics are not limited to 5-letter.
Oh, I see.
I'm just not that bright.
It's just
to come up with that.
5 letters out of the word.
Yes.
Okay, got it. All
I'll
right.
start to give you an example, and when you or I give the other person the jumbled letters, let's just pause for a moment so that the people listening or watching can pause what they're doing.
Oh, and
If they
try to
wanna
puzzle it
figure
out themselves?
We could have some puzzlers watching. I don't know. All right, but we're going to do
We're
that.
starting a trend.
Just because we like to imagine people. I like to imagine people playing along.
Okay.
All right, so first one, I'm going to start giving you one, and it's going to be TRINB, T-R-I-N-B. T-R-I-N-B. So what handbook topic includes all of those letters that we want to talk about today?
All right. I think I've got it.
I have faith in you, sir.
Okay. Arbitration.
Arbitration.
Because that just really is one of the number one things to talk about with regard to handbooks.
It is, and something, frankly, that people don't talk about enough, in our opinion, and there's been a change in the law.
There has, right, exactly. And you're the expert on that. So tell us about that change, will you please?
Well, let's not get crazy. But there has been a change.
Between the two of us, you're the expert on that.
In this room, I have the most expertise.
Yes,
All
you
right.
do.
So earlier in 2022, the federal government actually passed a new law dealing with employment arbitration clauses. And for folks that might not even fully understand what we mean when we say arbitration clause, don't worry, we're going to get to that in just a minute, so hold on. The law is, it's a mouthful. It's called the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act.
Wow, that would be the IFA Sasa. IFA Sasa.
Clearly, marketing was not involved.
Yes, right. Okay.
But what I like about that one, it does not have a cute acronym that rolls off the tongue, but it is fairly descriptive of what the law actually does.
Yeah, you don't have to actually read it, right? you know what it does.
We don't,
right?
but guess what? I did so that no one else has to. And
Okay.
what this new law says is if employers are going to ask employees to sign an arbitration clause, which again, we're going to talk about in some more detail in a minute, but in basic terms means that an employee is giving up the right to bring a lawsuit for an
Right.
employment claim.
Okay.
They have to go to something called arbitration, which we're going to explain. If an employer is going to do that, that's still okay, but they can't enforce it against employee claims that deal with sexual harassment or sexual assault.
Okay.
Now, the employee still has the option, if they would like to, proceed with arbitration
I see.
in lieu of a lawsuit. So it becomes the employee's choice. An employer cannot require an employee to go to arbitration instead of bringing a lawsuit. So that
Okay.
is the change. So for our clients who are already all over arbitration clauses, know what they are, have them, expect them to be enforced in every situation, those folks should know that they can't do that anymore with those specific types of claims.
And I would imagine we would want some rewriting to be done to their existing arbitration clauses, right? To make sure, as written, it's in compliance with the IFA Sasa, right? Right? So
Every time I'm having a bad day and need a giggle,
yes,
I'm just going to walk by your
watch
office.
me struggle with that acronym. You'll think back to that. So any of our listeners who have current arbitration clauses, frankly, whether in a handbook or not, should be going to their legal counsel and asking what revisions should be made to make sure they're complying with that new federal law. And to be clear, that's a federal law, that's not a
Correct.
state law. So regardless of where your operations are, where your employees are, et cetera, that is going to apply to you.
Correct. Okay, so
Okay.
now let's help out the group of folks whose heads are spinning.
Yeah.
Before we even get to what is an arbitration clause, what is arbitration? What is an arbitration clause? And is that something we should have in our handbooks or not?
Right.
Right? So arbitration is an alternative dispute resolution process, an alternative to litigation, in other words. It's where the parties agree on a decision maker who's not a judge. Arbitrators are privately employed people, right? There are firms,
Right.
companies that supply arbitrators. It can be one arbitrator. You can have a panel of three. And that person or persons decides the dispute for the parties, and that is
right.
in lieu of litigation. So if you have an enforceable arbitration clause, it means that when an employee has a potential employment lawsuit against you, they can't go to court, you both go to arbitration, right? And so this may sound really good to people, right? That, let's see, wait a minute, I can't get sued.
We get to pick our decision maker.
Why doesn't everyone have an arbitration clause, right? So let's talk about the pros and cons that folks should be considering, and whether employers end up putting an arbitration clause in their agreements or not, or in their handbooks. It's certainly something everyone should think about. It should be an intentional decision.
Right.
It should not be absent because no one thought of it, right?
Correct. Yeah.
So what are some of
Right.
the advantages of arbitration,
Right.
Sarah?
And I'll just add too, not even lawyers agree on whether arbitration is a good idea or not, right? There are different ways to look at this.
Yes.
And to your point, pros and cons.
Specific, right? It can be very
And-
organizational.
Exactly. And
specific.
so as they apply to your organization. So
Yeah.
some of the pros, of arbitration are, well, number one, it can be a faster process than litigation in court, right? For any of our listeners who have lived through an employment lawsuit, meaning something
Right.
filed in court,
They have a little
and
PTSD now.
Yes, and gotten all the way to the end of that, they know that it's almost always over a year and often more between the time that the lawsuit gets filed and some sort of decision is made, whether the case is dismissed or whether it's tried in front of a jury, et cetera. That is a long process. That's a lot of time. And all during that entire time, that business is spending their time and money on that lawsuit, right? Their time focusing on it, thinking about it, and their money, of course, paying for the defense of it. One of the biggest reasons employers choose arbitration is solely because arbitration, in general, overall, tends to be a faster process and a less expensive process, at least to defend.
Usually.
Usually.
Yeah,
Not
not
always,
a guarantee.
but usually. Yes.
And an employee's lawyer who doesn't want to go to arbitration, would rather go to litigation, will sometimes litigate over whether they can be forced to go to arbitration in the first place.
Right.
So you may end up with litigation, even though through an arbitration clause you are trying to avoid litigation.
That's correct.
Right? You might have litigation and an arbitration.
Right. First litigate in court whether the arbitration is enforceable and then actually arbitrate it. The other thing I'll add too is, gosh, I think it's been at least 10 years now, Rebecca, since there was a different federal law passed that really added some pretty substantial requirements for our arbitration agreements to be enforceable, right?
Correct.
And those really almost mirror what happens in federal court, right?
Yes.
Now, employees have to be able to take what's called discovery and depositions and exchange documents, et cetera. So all of that still happens in arbitration. Again, overall, it can be faster, but that difference is not what it used to be, right? 25 years ago, employers could plop an arbitration clause in an agreement and say, we're going to arbitrate it next month, and it would get done. That's no longer the case.
Another advantage of arbitration, though, is privacy, right? Some people prefer it. So litigation is public, right? Almost everything is available to the public.
Right.
The very
Excellent point.
fact that you got sued is certainly public, and then most of the pleadings throughout the lawsuit will be public. So some employers prefer arbitration because it's private. Right? Certainly high wealth, high net worth divorces, right? They often prefer arbitration, but in employment cases too. So that is one advantage to arbitration over litigation. So for clients, for organizations where their public image is extremely important to them, they may want to consider arbitration.
Yep.
Right?
That's a great point. Yep,
And
absolutely.
So any other pros or cons of arbitration clauses?
Well, I mean, one, depending on the circumstances, this, I suppose, could be viewed as either a pro or a con. And that is arbitrators in general tend to make decisions based more on a sense of fairness and equity rather than a strict application of the law, right? And a lot of HR folks in our audience know, right, that under the law, an employer can't be sued just for being unfair. That's not a claim.
That is absolutely correct. Yes. Our
Now,
clients rely on that quite a bit.
correct. Now, there are claims, of course, that are based instead on unlawful discrimination, retaliation, etc., right? So by and large, and this is a generalization, but by and large, judges tend to be more inclined to stick to what the law says, to apply the law as it's written. Arbitrators, on the other hand, tend to like to find some sort of middle happy place, right? If an arbitrator thinks an employee has been treated unfairly but not discriminatorily, that arbitrator might try to give that employee something nonetheless, whereas a judge would simply dismiss the case.
Right. And what else can arbitrators do? And it's not unusual for them to do
it, and that is bring somebody back to work. So a common result in arbitration can be reinstate that person, but without back pay, right?
Yeah.
That's the kind of middle ground that arbitrators tend to like to find. Now, as I said, I think in some circumstances that could be viewed as a pro and not a con. It just depends, right?
Yep.
And some businesses may like that idea of a third party trying to lend fairness and equity into that process. As lawyers, it makes us very uncomfortable. We like to apply the law as written, of course.
We do. And some of these decisions may be based on, we mentioned they were very specific, right, to the organization.
Right.
Sometimes whether an organization wants an arbitration clause or not may just depend on where they're located.
Yes.
Right? And the courts in their jurisdiction.
That's a valid
or venue. Lawyers
Yep.
like to talk about it in terms of venue. If you have judges in your venue, in your jurisdiction, that are generally hostile to employers and very employee-friendly in litigation, you may be more inclined to want an arbitration clause, right?
Yep. Okay.
Okay, one last point on that, and then we will move on, I promise.
I need to give you your letters, so, right?
I'm trying to put that off.
Right.
But what about arbitration clauses just for certain types of claims, but not others, right? That could be an option. We're getting outside of the handbook world, so really we're not going to spend a lot of time on this. But if you have separate non-compete agreements,
Right.
for instance, you could have mandatory arbitration clause attached to those agreements and not to all claims and not in your handbook. And then one final point, this is not a DIY type of thing that HR folks can put together themselves. As you mentioned, there's a lot of requirements for an arbitration clause to be valid and enforceable. So
Right.
you certainly don't want to go through the whole process of thinking about whether you should have it, talking to the C-suite, getting everyone on board. Everyone thinks there's going to be mandatory arbitration, and then lo and behold, you can never enforce it after spending lots of money on litigation for a judge to tell you that.
Before you even get to the underlying claim.
That is
Valid
one of
point.
those things that has to have some legalese and has to be done correctly. Okay.
Okay, so
Next one.
next handbook topic. Are you ready for the letters?
Try me.
They're letters that seem to coincide with your name, but RECBY.
Okay.
The answer is not Rebecca, not call Rebecca. REC.
Well, there is the Y in there, so that
Yes.
threw me, and no one's ever called me
Yes.
Becky, so it can't.
Okay.
And I, as far as I know, have not been a topic in a handbook.
RECBY.
But there's
What do you
always,
think?
there's a first time for everything, the Rebecca clause.
RECBY.
Yeah, I think this one is a 5-letter word, because I can make that into a 5-letter word.
All right,
Into
let's hear it.
Cyber,
You got it.
right? Cybersecurity,
Yes.
data privacy,
Yes.
computer use policies.
Yes.
Okay, so
As an employment lawyer, I just want our listeners to know what you just said makes my skin crawl. So if they heard you say cybersecurity, data privacy, and their hair stood up on end a little bit because they thought, oh my God, I don't know what I'm supposed to be doing about that, but there's probably something to be done in the handbook. Know that Miller Johnson has a cybersecurity practice group.
yes, which we both rely on in our employment practices, right?
Yes. So whenever I get a handbook, part of that review involves sending it to those experts to say, okay, here are the states in which these employees are working. Please make sure they're in compliance with all of these data privacy and cybersecurity laws.
Yeah, it can vary by state. It can even vary by large cities within some states, right? For instance, folks in Chicago have specific issues they need to be aware of. So it can even get more nuanced than that. So let's talk more in general. A handbook obviously can't protect your data, right?
No, unfortunately not.
We'd both be retired in Hawaii if we could come up with a handbook clause that guaranteed your data would be secure. But what can we do in a handbook that's kind of keeping up with the times, right, as things have evolved? One is when people bring your own device, BYOD, I think is the acronym a lot of organizations use. We've seen a lot of confusion over what happens and who owns what.
Oh my
what
goodness.
happens when you use your own laptop or phone and then you leave the organization, right?
Especially the phone.
especially the phone. Are we going to actually require employees to wipe their phone, which will include their personal contacts as well as business, personal picture, right? All the things. Obviously, we all, our phones are our lives at this point. There's, just like arbitration clause, this is something to think about on an organizational level and can be very client specific, but it is something to think about and something that
and
should
let
be
me
addressed.
just add too, it's not just the phone, it's also the phone number.
Yeah,
Okay,
so people do not want to
particularly-
give up their phone numbers, Sarah.
Well, and particularly, this comes up a lot with, for example, sales employees.
Yes.
Who, well employed, were communicating directly with our very important customers, right? Now they've left, and they might be working for a competitor. We don't want our customers to continue to be calling them on that number. We want to own the number.
Yep, exactly. That comes up far more frequently
Yes.
than a lot of folks would like.
Yeah.
Let's talk about what kind of information we can get from our own devices or from our employees' devices that are being used for business purposes. And this comes up in litigation or when we're doing an investigation, right? What can the employer have access to that doesn't open itself up to a breach of privacy claim, for instance? So it's important to have the policies drafted in such a way, right, that are crystal clear, not just our own devices, but also devices you use for business purposes.
Yep.
Right? And also apps or email programs, et cetera, that are quote unquote private, Gmail, Yahoo, but you're using our computer and our network.
That's right.
To access
That's right.
those emails.
That's right. And if our audience is looking for us to answer that question right now, we simply can't, because that depends on state law. That is a state law analysis, right? So, so for today, all we can say is your handbooks, I am sure, across the board need updating to comply with cybersecurity requirements and to address these concerns. And those are all going to be specific to different states in which employees work.
The last thing I think folks should keep in mind when looking at their computer use policies, cyber policies, is access and use.
Yeah.
So we see a lot of policies, ones we didn't create ourselves, that talk about what devices, information, et cetera, can be used by employees. And it usually says something like, our information that's stored on electronically on our electronic device can only be used for the benefit of this business.
Right.
I'm oversimplifying, but that's basically what it is. What we would like to see is to also limit access to those devices and information. Right?
Yeah.
Because
right.
that, for reasons that will completely bore our listeners and watchers, but that opens up a whole new level of federal liability under a certain federal statute, both civil and criminal, to an employee that accesses information. It becomes a hacking issue,
right,
as opposed to like a trade secret
right.
or a using the information for competitive reasons. If you have restricted access itself, now we've got a hacking issue.
Again, so happy that we have folks like Jeff Muth and Jason Crow at Miller Johnson who have decided to spend their days doing nothing but cybersecurity issues to help us and our clients out in that
And
way.
when there's breaches too, right? Those are our go-to. That's our go-to practice group, not just in prevention, but in breaches. All right, are you ready?
I'm ready for the next
one?
changes, hot handbook topics. I'm ready.
I'm not sure how I'm going to pronounce this. MAFON.
Oh.
M-A-F-O-N. MAFON.
Got it. All right.
Are you cheating?
I am cheating. I'm looking at the answer because there is absolutely no way. If any of our listeners got the answer from those 5 letters, they need to reach out to us so that we can send them a prize. I will.
Did you ever cheat in high school and get away with it?
Am I under oath? All right. Non-FMLA leave is the answer to that one. Non-FMLA leave. Again,
So I think I put FMLA in there. I did not.
You did not.
No, I decided to
So
make it
non-FMLA
really
leave, of course, one of my favorite topics, right?
Well, wait a minute. I thought FMLA is your favorite topic. Are you including now non-FMLA too?
Yeah.
Okay.
Any medical issues in the workplace just is a large topic.
So COVID has kept you busy.
Yes, exactly. So anybody updating a handbook now should really be including a written policy that talks about leave as a reasonable accommodation under the ADA. Even if you don't want to use those terms, you should have a policy in place that sets forth a process that is going to be followed if an employee needs time off work due to their own health condition and they either are not eligible for FMLA leave or have exhausted their FMLA leave.
Do you recommend a policy like that in a handbook for employers who have less than 50 employees?
Absolutely.
In other words, are not covered
Sure.
by FMLA,
Yes.
as well as those who are covered by the
Absolutely.
FMLA?
Absolutely. Yep.
Okay.
You
And
got it.
it's important for those smaller employers to be clear that it's not FMLA and not to mention FMLA,
Yes.
right? Because they could create an expectation.
That's a leading question, but the answer is yes. That's exactly right.
I knew what you were going to say.
Yes, absolutely, right? So when you're updating the handbook, look at your leave section. If you're covered by the FMLA, I'm sure you have an FMLA policy, and there's probably a military leave policy and a jury duty leave policy. I'm still seeing a lot of handbooks that just really are completely silent as to medical leave, meaning for the employee's own health condition, and when it's not covered by the FMLA for one reason or another.
And when it's not,
and that's an easy fix. That's an easy policy to tailor and put into a handbook.
and you can also help tailor the process too.
Oh
for
my goodness,
when
yes,
someone
yes.
needs non-FMLA
Yes,
leave, because we
yes.
see a lot of HR departments
We
kind
spend
of
a
get
lot
tied
of
up
time.
in knots.
Yeah, we spend a lot of time doing that and then put together a lot of processes,
Right.
forms, letters, et cetera, that really help HR departments know what to do when that arises and in compliance with the ADA.
Perfect.
So-
Okay. What do you got for me?
I got 4 letters. You gave yourself an easy one.
A
Ready?
4-letter word that starts with
SALF.
I did give myself
Self.
an easy one.
SALF. Come on.
I'm going with Fair Labor Standards Act, Sarah.
FLSA. You got it.
My
right.
favorite 4-letter word that starts with an F.
Yes.
So why are we talking about the Fair Labor Standards Act? What has changed? Something is going to change soon, perhaps by this time this podcast airs. The Federal Department of Labor has announced that they are going to increase the minimum salary that exempt employees must earn in order to be considered exempt.
Boy, that's something that everybody should be paying attention
So
to.
we will do a separate episode just on that, because
exciting.
you know I'm going to want an episode on the Fair Labor Standards Act. But for today's purposes and handbook purposes, it's important for employers to realize now that they are going to have more employees who are non-exempt than they did in 2021, right? In 2022, you're going to have more and ongoing.
Because the salary basis is going up.
Yep, salary
Got it.
base is going up. More people just won't meet it, even if they meet the duties test, or they're going to be non-exempt. So, as we mentioned at the beginning, lots of folks are reviewing their handbooks now. So, in anticipation of having a higher percentage of the workforce non-exempt, this is a great time to look at those overtime pay policies and timekeeping policies, right? And make sure they're as good as they possibly can be. With timekeeping policies, I think it's very important in handbooks to make sure it's clear that it is the employee's responsibility,
Yep.
right, to inform the employer accurately and on time, promptly, of all hours worked. And this is critical. If the employer has any sort of automatic
Yep,
deductions, like for
deductions.
meals, or sometimes employers pay to the schedule instead of pay to the punch, if that's a topic that's new to people, give me a call. But there are ways sometimes that employers automate, right, certain timekeeping.
Sure.
And then they do that. They do have to allow for exceptions. They have to say in the handbook how an employee can take advantage of those exceptions, how to report it. Make it simple, put it in the handbook, make sure the employee signs off on that. That is great protection for the employer.
I was going to say, that's an example of something, if done right, provides an incredible defense to a claim.
Yes.
If not done right, is a huge problem.
Yeah, that's an example of something in the handbook. They can save the
Low-hanging fruit.
organization
Yes.
lots of money.
Lots of
Another area you should look at in your overtime policies, please don't have them say, we will not pay you overtime if you did not get your supervisor's authorization ahead of time. You can require supervisor authorization,
Yeah.
but don't include the phrase that we will not pay you if you did not
Because
get it.
that's unlawful.
That would be unlawful if you, it's not unlawful technically to put it in the handbook, just to be clear, but it would be unlawful to actually not pay someone, right? It would be unlawful not to pay someone.
Yep.
Just because they didn't get supervisor authorization. So I continue to see those in handbooks that we did not prepare. Okay, next, are you ready?
I'm ready.
All right, this is, you gave me an easy one, so I'm going to give you an easy one. This is actually a 5-letter word. DCOIV. I cannot pronounce it.
Right.
I could not figure out a way to mix up those letters and make it a pronounceable word. DCOIV.
And of course, it's COVID.
It's COVID.
Right. Now, at the beginning of this, we said that this was not a COVID podcast.
Right.
So this is it was a bit of a curveball.
You know, I'm
Right.
sorry. I'm sorry. We have
but
to
that's
mention the
okay.
C
And
word.
I think this is a valid point because I know where you're going with this. We have lots of businesses who drafted policies during COVID.
A lot of policies.
A lot of
sometimes.
policies.
Well, we should say policies that went through many versions.
Yes. Well, remote work policies, for example, policies to comply with Michigan's Public Act 238, which is the one that provides attendance protection, right, for COVID-related reasons, safety policies, et cetera, right? So when these folks are now reviewing their handbooks, they're trying to figure out, what do I do with these things, right?
Should they go in the handbook?
Should they go in the handbook or should they not?
What do you think?
I think it depends. Isn't that a great answer?
That's always your answer. It's always my answer, too.
I think it depends. There are certainly policies on topics that arose during COVID, but are still very relevant. And the biggest example I can think of is a remote work policy, right?
Exactly. Yep.
Absolutely. You're going to want to rewrite that if it was written only to address COVID times, right? We're going to want to rework it, but almost certainly put that in the handbook.
Yep.
A policy that is, on the other hand, just about the types of hygiene and sanitizing we're going to do because of COVID, that likely probably does not have to land in a handbook and be placed there forever and ever.
I completely agree, but maybe some employers may want to consider, like in a standards of conduct, right, including that employees have to comply with any and all policies, right, temporary or permanent,
Right.
that employers may
Valid
adopt
point.
to address pandemics, national health emergencies, et cetera,
Yes.
et cetera, right, for
Okay.
the mask issues.
Yep.
Who knows
Valid
what's going to
point.
come down
Yeah.
the line in the future, and there was no handbook, no one had a handbook policy that covered anything, right, that was really relevant.
That's right. That's right.
to COVID.
We didn't know. We just didn't
We didn't know. Now
we
we
didn't
do.
know. All right.
Should we do one last one?
One last one. 5 letters again. This is
We did try to get 5-letter words that were also
5-letter words. LUTIM.
Lutein?
Lutein.
Sounds like the newest pharmaceutical. for
Right.
anxiety.
It does. It does.
Okay, lutein. Multi.
Exactly.
Multi
Exactly.
what? People are tired of hearing us
Longtime
say
listeners
this.
probably got that right away because they know at some point during almost every time we talk, we
Right.
can't help but talk about multi-state, right?
Multi-state. So we can keep this short because we have talked about it in terms of specific issues, right?
Right.
Already during this podcast and in others. But the thing to remember is if you have employees in other states, even remote workers, right, who are working from home, for
Yes.
instance, which makes it a facility of one in another state, you do not have to revise your entire handbook to be compliant with every single state in which employees work, but you should consider having what we call a rider or an addendum that is state specific at the end of the handbook.
For those states, yep.
For
because
every state
there
in which you
will
have
be unique,
one employee.
Exactly. There will be, in just about every state, there are some unique requirements, things that are going to apply to that employee. I personally don't like having a different handbook for every state. I think that's incredibly complicated, and
Right.
then whenever you update the handbook, you're updating 17 of them or whatever, right?
Good work for us.
Exactly.
Not a good result for our clients.
Yes, have one solid handbook that's compliant, and then have separate addenda for each state that have those sort of unique one-off differences in state law.
Yeah, so there's an easy solution to
Yes.
having employees
Yes.
in multiple
Yep.
states, but it is something
And
our
of course,
organization should be thinking about.
right. And of course, we've got that.
We do.
So, okay, just 2 honorable mentions here.
Final thoughts.
If okay, final thoughts.
Okay, yeah.
These are my other go-to things. Number 1, this is a consideration that's been present in handbooks since the beginning of time.
Something
right?
present in handbooks since
the beginning of time. And
time?
that is handbooks that have things that the employer, that are written as if they're supposed to be a contract or the employee is bound to it.
Okay.
The biggest example is some sort of confidentiality of information provision, right? You are going to have access to confidential information, you have to keep it confidential, et cetera, which is a nice thought, but then the handbook almost certainly is also going to say that it's not a contract, right? Which means your confidentiality provision has now become a suggestion and nothing more, right? It's
If it
just
so
an
moves
ask.
you.
Yes,
If it so moves you,
please keep our guy. Yes, exactly. It's not a contract, right? So we've got to manage those things, right? And there's a number of different ways to do it. But just know if you have those things that are written like they're supposed to be an obligation by the employee, like that you might want to someday actually enforce, right? We've got to do it differently. You can't have it in a handbook that says it's also not a contract.
Right, and then come to us to say we want to sue an employee for violating the handbook.
Exactly.
Yeah.
And then the last thing is just kind of a hot topic, and that's social media
Oh, yes.
policies, which
Still.
of course, yes, still.
Always.
Right.
Yeah.
Opens a conversation about what can we monitor, what can we say in a policy, et cetera, et cetera, et cetera. So that's another thing to think about.
Something I see with social media policies that I think could use some updating perhaps. Older social media policies were very negative towards social media.
Yeah.
Right? You shall not identify your employer. You shall not ever
Right.
use the employer's name. You shall not, you shall not, you shall not. But as we've seen, social media can be a tool for positive and for recruiting in this tight labor market, right? And we've seen employees use social media to the organization's benefit. So if we can help you shift those policies, saying we'd actually like you to use social media, right, to enhance our organization's goals, but here are the guidelines, right? There are some lines you can't cross, right, when you're doing that, but otherwise, absolutely okay. Right, absolutely okay to tell people you work here, you love it.
I really like that.
Share our recruiting, right, notices, those sorts of things. Frame it more positively.
And on that note, okay, one last thought about handbooks.
Okay, this really is the last one.
This really, I promise it's my last thought. Rebecca knows me well. I say that a lot, and then I keep talking. One last thought, and that is this. I would love employers to be thinking about how to have their handbooks be presented and read in a way that reflects the culture of the organization that they want people to recognize.
Yes.
Right? We've seen some great ones.
Yes,
Right?
completely
Graphics, fun, and the way the information is presented doesn't look like stodgy lawyers wrote it. Right? Okay?
Who wants to read our stuff?
And right now, in this labor market, employers are looking for any way to set themselves apart. And I think that handbooks are something that the people you hire see almost first, right? And gives them an immediate impression of where they're working. And I think it's important to be thinking about that and go take that next step to not only deliver the information, but deliver it in a format that is fun if you're a fun company,
Right.
right?
I completely agree. There are a few legal terms here and there, but it's actually not as important as some people may
Right.
think, right? It's important to have topics covered, but how we say them,
Right.
can definitely reflect
It's time
the
to think
culture.
outside the box,
Yep.
in other words. So
Completely
okay.
agree. Okay.
With that,
Thanks, Sarah.
all right, and I've got an idea for next time too. So
Oh my gosh, are we going to do a teaser?
yeah, it's
Okay.
something. So we know HR folks are thinking a lot about handbooks now. That's sort
They
of
are.
been their go-to now that they're thinking past COVID. And I've been thinking about a topic that I'm hoping they're thinking about. And we're going to talk about that next time.
Normally we do themes that our clients
Yes.
are calling us with. This is a theme in your
me.
own mind.
This is me walking around worrying about our listeners and our clients and businesses and hoping they're on top of this. So
Okay, I can't wait to hear what it
I
is.
know.
All
All
right.
right.
Until next time.
thanks, Rebecca.
Thank you.